Good afternoon, everybody. Well, it's a great pleasure to have the opportunity to participate in this year's St. Petersburg International Legal Forum, especially as the event approaches its 10th anniversary. A city that boasts some of the world's finest art collections and offers a unique architectural blend of Baroque and neoclassical hardly needs a reason to visit. But if one were to look for one, a mammoth event such as the St. Petersburg International Legal Forum, titled somewhat mysteriously this year, the Forum 9 1/4, would surely make it to the top of my list. Well, I thought it might be helpful if I share some thoughts today on the future of London as a place for dispute resolution for Russia-related disputes in light of recent changes and challenges, the UK's departure from the European Union, the COVID-19 pandemic, and increased arbitration competition from other centres. Well, as you know, London has for a long time been a popular forum for resolving Russian disputes, attracting some of the largest high-profile disputes from the region. And I know that one of the panels is going to be looking at London as a forum for disputes, so I hope that my remarks will be of some relevance to the audience. Well, many of you, particularly those with experience in international disputes, may wonder whether, in light of recent events, London will be able to maintain its role as a leading centre for the resolution of international disputes. In other words, what does the future hold for the city as a place for resolving international disputes and disputes with Russian parties in particular? Well, a full account of my thoughts on this subject would be long and far exceed the limits of the organisers' indulgence, so let me give you my answer right away. My view is that London will continue to have a number of enormous advantages as an international arbitration centre, despite Brexit, despite the pandemic, and despite the latest sanctions. And while there may be challenges, none of this will lead to a diminution in the merits and popularity of London as a seat of arbitration or damage the popularity of English law as the commercial law of choice for many international transactions. I'm confident that Russian parties arbitrating in London will continue to have a positive experience and that their disputes will continue to be resolved both fairly and expeditiously. You know, this is not mere bravado or wishful thinking from a British practitioner. It's soundly based, and those who are thinking and plotting otherwise should look at the hard facts. First, and this is a general fundamental point that I think true of many of the challenges the city has encountered, London is a tremendously resilient place. Outside commentators have said on many occasions that its days as a leading dispute resolution centre were coming to an end. But on each occasion, London has bounced back and often bounced back even stronger. Indeed, it's bouncing back at the moment from the pandemic. Second, London has many important attributes when it comes to dispute resolution. A few years ago, during its centenary conference in London, the Chartered Institute of Arbitrators published a list of 10 features necessary to make a safe, effective, and above all, successful seat for arbitration. They were drawn up after a detailed consultation process with experienced arbitrators and arbitration lawyers. Well, the principles covered law, the judiciary, legal expertise, education, right to representation, accessibility to the seat, functional facilities, rooms and amenities, for example, ethical standards, enforceability, and arbitrator immunity. Well, I don't have time to go through them now, but the important point for present purposes is that the UK and London have all these attributes in plenty. For example, the 1996 Arbitration Act has already been tested and implemented by a cadre of highly qualified judges in arbitration law, and London has a tremendous body of arbitration practitioners. Thirdly, and importantly, as I've argued elsewhere, none of these principles depend on the UK's membership of the European Union. Indeed, European Union membership wasn't even mentioned when the 10 principles were being discussed and developed. It's now nearly 5 years since Brexit was announced, and a good few months since the UK's formal departure from the EU. Yet the number of Russian disputes that go to London arbitration remains constant and high. At the London Court of International Arbitration, for example, Russian and CIS disputes consistently account for 1/3 of cases, a figure that has remained stable despite talk of some parties switching to Asian forums, according to Van Herse van Hoof, Director General of the LCIA. It's not the treaty establishing the European Union. It's not the Treaty of Rome, which is essential for arbitration or for a place to be a good centre. It's the New York Convention. And England, the United Kingdom, remains fully a part of that. So those are the reasons why I believe London will remain an important, indeed very successful arbitration centre. Let me therefore end here and say simply this: stay safe, everyone, and I hope it isn't long before we can meet again and enjoy the much-loved Forum's cultural programme and the hospitality that the city is known for. Thank you and good day.